attorney with the law firm of Enea, Scanlon, and Sirignano. We are located in White Plains, New York, and we also have offices in Somers. And predominantly, our practice focuses on elder law and trust and estate work. It has a lot of the same undertones as trust and estates. We write wills, we do estate planning, but we also focus on the unique issues that predominantly affect senior clients and preserving their assets from the cost of long-term care, handling situations that might arise for them as they age, such as incapacity, the need for a guardian, as well as doing probate and estate administration after they pass away. A big area of elder law has to do with Medicaid planning. And sometimes when people hear Medicaid, they just think Medicaid as an insurance for individuals who do not have funds or are not eligible for Medicare. But Medicaid has a lot of other benefits as well, including care at home, long-term care at home, and providing benefits for individuals to stay in their home long-term, and also nursing home Medicaid. When someone needs care in a skilled nursing facility, Medicaid is an option to pay for the cost of that care if someone is eligible for those benefits. The first of the advanced directives we're going to talk about is a healthcare proxy. So a healthcare proxy is a document that allows you to decide who you want to make medical decisions for you if you cannot do so yourself. Because the moment someone turns age 18, their parents can no longer make medical decisions for them. Technically, that parent can't call up the doctor's office, make a doctor's appointment for their child, go to the doctor's appointment, or speak to the doctor. So in the event where someone is unable to make their own medical, or if even short term, they're in surgery and a decision has to be made while they're in surgery, having a healthcare proxy is critical. You can appoint anyone to be your agent for healthcare decision making, and that person is then legally entitled to act on your behalf. So who's making that determination? Is it a judge that has to make a legal determination of incapacity? If so, that might be a very long, costly process, and also not be the intent of the individual who wanted to create the power of attorney, which the goal was to avoid having to go to court and appoint someone to become his or her guardian or get a legal determination of incapacity. Durable general powers of attorney can be helpful in situations such as if I am in the hospital or during COVID, for example, when people could not make their way home from certain situations, whether they were abroad or otherwise, and things needed to be handled somewhere else. Powers of attorney could be executed to allow someone else to make decisions for that person, even while they have full capacity to do so. Now, sometimes clients can be concerned about that. Well, why would I want to give someone else authority to do things for me today? And the advice that I often give them is we don't have a crystal ball. We don't know what might happen in the future. So making sure you have something in place now helps avoid those needs for guardian, et cetera, in the future. And the biggest decision they need to make is finding someone that they trust implicitly to act as that agent under the power of attorney. Truthfully, we all have enough financial things that we have to deal with of our own during our life. Usually someone does not want to touch someone else's finances unless they absolutely need to. So if a parent became incapacitated, the child would then be able to utilize the power of attorney to continue paying for expenses, paying their bills, accessing assets, and taking other legal actions that might need to be taken. But truthfully, appointing someone that you trust and finding the appropriate person to appoint is very important and sometimes can be lengthy conversations with clients. They should look toward, someone that has the financial abilities to handle the assets that they have. If they have, high net worth investment assets, they have multiple businesses, multiple properties, appointing someone as their agent under a power of attorney that they not only trust, but might be able to handle that type of job should be considered. So The power of attorney can also be structured depending on what the person needs to do. So in our office, because we do a lot of elder law planning, gifting of assets becomes very important, not only from a Medicaid perspective, but also from an estate tax perspective. So our powers of attorney often have very, very broad gifting authorities, where an agent can essentially give unlimited gifts in equal, unequal amounts to themselves, to others, as long as it's in the best interest of the principal to do so. Power of attorney law is governed by the General Obligations Law, Article 5, Title 15. It was recently updated in June of 2021, the General Obligations Law, to change the power of attorney form a bit. If you're familiar with the power of attorney, it's a statutory form. So there's pretty strict instructions as to how the power of attorney needs to be drafted. And prior to 2021, there was something called a statutory gifts rider, where if gifting authority was being provided for in a power of attorney, a separate rider had to be executed in front of two witnesses and notarized in order for gifting authority to be done. It became very complicated, especially for elderly individuals and practitioners, as to whether or not the power of attorney needed this rider, whether it didn't need the rider, if the rider should be stapled to the power of attorney, when it needed to be executed. It became very confusing. So the new power of attorney law has done away with the statutory gifts rider. Everything now in terms of gifting authority is included in the modification section of the power of attorney, and that's for any power of attorneys executed after June 13th, 2021. So the power of attorney, like I was saying, can either be very simple or it can be very broad. A standard power of attorney has certain general provisions. They're usually on the second page of the power of attorney, and they give the agent authority to do typical things that your client might do during the course of the year: pay their bills, file their taxes, handle business operations, estate transactions, purchase things, sell things, handle all tax matters. And then there's a last provision called all other matters, which can sort of act like a catch-all for any type of transaction that doesn't fit into the general provisions. So, for example, if you're doing a simple real estate transaction for a client, you might have them do a limited power of attorney that just gives authority to do real estate transactions for a specific period of time. But you don't want to be their agent for financial decision making. You know, if they become incapacitated 20 years ago, you want that power of attorney to terminate after that closing occurs. The type of power of attorney that I'm talking about is not something like that. Mine is really to ensure that if something happened down the road, someone else could take care of things for this person indefinitely while they're alive and handle whatever comes through the door at that time. So usually all of the general provisions are included in the power of attorney, and the individual creating it would give these authorities to their agent. The second part of the power of attorney is the modification section, and this is where those gifting authorities are often held. Some powers of attorney might have no modification sections at all. When dealing with the elderly population, estate planning clients, I think it's extremely important to have a robust modification section. You want to make sure that that client is giving authorities to the agent that that person might need in the future, so that they could essentially step into the shoes of the principal and handle whatever they need to in that situation. So it often includes power to gift assets, trust transactions, creation of revocable and irrevocable trust, entry into a safe deposit box, retaining attorneys, accountants, aides, home health aides, personal service contracts, the ability to make statutory elections and sign documentation for Medicaid applications, such as spousal refusal forms, Medicaid applications. It should also include provisions as to digital assets and devices. So an agent under a power of attorney can gain access to the principal's digital assets, devices, accounts associated and included in those digital devices. My power of attorney also includes a very robust section about business modifications and business operations. So if the individual who's creating the power of attorney has any business entities, any corporations, LLCs, PCs, etc., they have authority to handle those as well. Now, as practitioners, another thing, especially solo practitioners, one thing that I do recommend is also considering doing a limited power of attorney to handle a law practice. You can only give that type of power of attorney to another practicing attorney, but especially if a solo practitioner becomes incapacitated, no one really has access to the books and records to pay employees to handle those confidential matters in order to continue running or winding down that law practice. So often solo practitioners may execute a limited power of attorney, providing that authority to another attorney who would be able to handle those things for them in that type of situation. Not really the focus of today's presentation, but just something to add for your own value. So the next document we're going to talk about is a last will and testament. And a last will and testament, if you recall back to your law school days, is a document that allows your client and you to memorialize where you want your assets to go after you pass away and who you want to carry out those wishes. So the people who receive your assets are called beneficiaries. The individual or individuals that you appoint to carry out those wishes and make sure that all expenses are paid from your estate, that money is distributed to those beneficiaries, are called your executor or executors. And trustees might also be appointed under a last will and testament if any trusts are created under that document. A common misconception that I hear from clients all the time is that they have a last will and testament, and that means that they're avoiding probate. So after they pass away, anything that they own just goes pursuant to the terms of this document. It would make sense because throughout those individuals' whole lives, they've signed papers such as beneficiary designation forms where they sign something saying who gets something, and they've been told that it just goes to that person. But a last will and testament doesn't work that way. In order for a last will and testament to be a valid document, it has to be admitted to probate, which means that the original last will and testament has to be admitted for probate in the surrogate's court in the county where the decedent resided at the time that they passed away, where they were domiciled. The executor who's nominated in that will has to petition to become the executor of that will and have the will admitted to probate. And then once that entire proceeding is done, that executor will get something called letters testamentary. And letters testamentary is what gives the executor authority to go out and get access to any of the assets that the decedent owned in their name alone, marshal them into the estate, deposit them into an estate account, or retitle assets into a estate account, and then they have the ability to pay expenses that the decedent had and then distribute money to the beneficiaries and wind down the estate. The will does not control assets other than assets that are in your name alone at the time that you pass away. So if your client owns a joint bank account, joint with rights of survivorship, upon their passing, those funds go to the joint owner. They are not controlled by a will. If a client has a retirement account or a life insurance policy that has named beneficiaries, and those named beneficiaries are alive at the time the decedent passes, those funds go directly to the named beneficiaries. They bypass the will. So it's really important when you're working with a client to ask those questions. Make sure when you're taking your intake, you're not only asking them what assets they own, but how they're titled exactly, if there are named beneficiaries, if there are contingent beneficiaries, because a lot of that matters in determining what's controlled by the will and how someone might want to formulate what that will says as well. Because regardless of what your will says, if the assets have named beneficiaries or are jointly owned, it goes to those beneficiaries. It's not controlled by the will. So, what does a will need to include? So, in order for a will to be valid, it has certain elements that it has to include. The will must have named beneficiaries. So, it has to say that assets go somewhere. It can be very simple. It could say that all of my assets go to my spouse if I am surviving, if he or she is surviving, and if not, to my children in equal shares per stirpes. It can be much more complicated than that. Individuals can have people as beneficiaries, entities, charities, corporations. Pets can also be named beneficiaries. Trusts can be named as beneficiaries in someone's will. The will can also indicate what types of assets a beneficiary will receive. So there can be specific bequests of tangible personal property, of real property, of specific bank accounts or specific dollar amounts. It can really be customized based on what your client needs and wants. But every will should have something called a residuary estate, everything else. So you can name 100 different specific bequests of assets to someone. I don't recommend it, but you could. But it should also include that if there's anything else in my name alone when I pass away, anything else that would be comprised of the residuary, where those assets go. And it's really important to not only name beneficiaries, but alternate beneficiaries and contingencies. Oftentimes, that might include grandchildren that may or may not be alive yet, or trusts for minor grandchildren, so that if individuals receive assets and they're minors, those monies would go into a trust for their benefit instead. A will also needs to include names of fiduciaries. So every will needs to name an executor to be able to bring forth the last will and testament to the surrogate's court and act on behalf of the estate. You should have alternate executors as well. You can name multiple people as your executors. So you can have co-executors, 2 people acting together, 3 people acting together. I've seen 4 people acting together. I don't recommend it, but it is possible. And also trustees might be appointed in a last will and testament as well for any of those trusts that might be created under the terms of a will. Trusts created under the terms of a will are considered and called testamentary trusts. Other important instructions and information that is often included in a last will and testament is guardian of minor children information. So for example, if you have minor children or a client of yours has minor children, they can indicate who they would want to become the legal guardian of their minor children or child in their last will and testament. It's not a binding appointment at that time, and the individual who is appointed under that will would still need to petition the surrogate's court to become the legal guardian of the child. But what it does do is it really helps the court decide who the guardian should be if multiple people are petitioning to become the guardian of the child, because the court gives great weight to the decision and request of the parent as indicated in their last will and testament. So I definitely think that it's important to have a last will and testament for everyone, but individuals who have minor children, it's really important to have that in the document. Because we've seen situations where, for example, both sets of grandparents or both sets of aunts and uncles might be petitioning to become a minor child's guardian, or someone else's. And the parent's decision and request can help the court determine who should be the guardian of the child based on what the parents would have wanted. Other instructions included in a will are tax implications and considerations. Where are taxes going to be paid from? Are all income taxes or estate taxes on the value of the estate going to be paid out of the residuary? Is it going to be pro rata calculated on all distributions, including specific bequests? Those are considerations that need to be indicated and outlined in the last will and testament. Often information regarding IRAs might be included in the will also. Now, typically, and not part of today's presentation, but typically you'd want to have individuals named as beneficiaries on IRAs with individuals named as contingent beneficiaries. But sometimes that doesn't happen. Or if those individuals have predeceased the IRA owner, then the estate might wind up being the default beneficiary and money goes into the estate. IRAs have income taxes that need to be paid upon someone's passing. And if money in an IRA goes into someone's estate, there's a very short window as to when that income all needs to be paid. If an individual receives the IRA outright, usually the income can be deferred over 10 years based on the Secure Act in 2019. So usually you do not want to have your estate as the beneficiary of your IRA, but there's a way to essentially manipulate language in the will so that a longer stretch period up to 10 years can still be created, even if the assets do wind up going into the estate. No contest clauses are often included in a last will and testament. Really, really important clauses, especially if someone is leaving assets to children, a spouse, other individuals in unequal amounts, or leaving someone out of their will, disinheriting a child. No contest clauses will often state that if someone contests the will and they lose, then they forfeit whatever they're receiving under the will. So for example, if you have two kids and you're giving one kid 70% and one kid 30%, and the kid that gets 30% decides to contest the will, they better be sure that they have very, very good grounds for doing so, because if they lose, they forfeit their 30% and they might wind up with nothing. Other important, last important provision I want to touch on is a simultaneous death clause. Important to have in order to ensure that if there are two beneficiaries that pass away simultaneously, or often within a certain time frame, that the assets continue to be passed down the line by indicating that each decedent predeceased the other, so that money can go to whoever the contingent beneficiaries would be. And especially for us as attorneys, it's really important that the last will and testament be executed appropriately. So there's an execution ceremony that needs to occur. No beneficiaries should be in the room when a last will and testament is signed. It needs to be signed in the presence of two disinterested witnesses. And there's usually, questions, or there is questions that need to be asked of the testator, the person signing the will. You need to make sure that they have capacity to sign the last will and testament. Interestingly enough, capacity to sign your will is the lowest level of capacity needed to execute a legal document. It, in case law, has been referred to as one lucid moment. So, and if my father was giving this presentation, he would tell you that you could be on Main Street in White Plains, running around in your underwear in the middle of the winter, and you could come up to our office and know what year it is, what day it is, who your kids are, how much assets you have, and sign a last will and testament, as long as you can demonstrate that you know those things. So it's very important that all of the requirements for a last will and testament are included in the document, and that it has a self-proving affidavit, which is essentially an affidavit that's attached to the last page of the will, indicating that the witnesses to the will are attesting that they saw the testator sign the will, that he had the capacity to sign the will, and that has to be notarized. Why that's important is because if a will does not have a self-proving affidavit, then those witnesses need to be tracked down at the time the will is going to be admitted to probate, and those affidavits need to be signed then. Which, if you work in this area, you might have a client come in today to sign their will when they're in their 60s. And if they live a long, wonderful life and they die at 95, you might have no contact with the witnesses that signed their will. You might not be alive yourself. So it's really important for the will to have a self-proving affidavit, that the will be affixed at the time that it's signed, and that the will be stapled either before or after the signing, as long as it's affixed during the signing, but it needs to be stapled. We have our clients initial every single page of the will as well. If you are an attorney that holds on to your original wills of clients as a courtesy for them, it's important to make sure that you have, something signed by them or a written notice to them stating that you're holding on to the original. If you're releasing it to the client, making sure that they know that they should not unstaple the last will and testament, that they should keep it in a safe place, and that they should not keep it in a safe deposit box. If a last will and testament is kept in a safe deposit box and it needs to be admitted to probate after the person who owns the safe deposit box passes away, it can cause an additional proceeding to need it to be done first, because you have to petition to get access to that safe deposit box to search it for a last will and testament before you can even start the probate proceeding. So while there are a lot of really good reasons to have a safe deposit box, putting an original last will and testament in one is not the best option. So what happens if you don't have a will? What happens if your client does not have a will and they pass away? If that happens, the type of proceeding in order to get access to assets in that person's name alone is called an administration proceeding. And it also has to be commenced in the surrogate's court of the county where the person was domiciled. And SCPA 1001 provides for a hierarchy of individuals who can obtain letters of administration from the court. So there's only specific people who can petition to become the administrator of someone's estate. So I said this before, I like my clients to be in the driver's seat. I want them to be able to make the decision as to who will be able to handle their assets after they pass away, and also who's going to receive their money. When they don't make a plan, New York State essentially makes one for them. So there's certain people that can petition to become the administrator. If you're married and you have children, your spouse and your adult children have the priority to have standing to petition to become the administrator. Under EPTL 4-1.1, that section provides for who receives assets when someone dies intestate without a will. So for example, if you are a married individual and you have 2 children, under EPTL 4-1.1, your spouse gets the first $50,000 of your estate plus 1/2, and your children split the other 50%. That might not be what someone wants. They might want all of their assets to go to their surviving spouse, and for their children to only receive assets after the surviving spouse passes away. If you only have a spouse, everything goes to the spouse. If you're a single individual, non-married, no children, then everything goes to your parents. And if you don't have parents alive, to your siblings. And if you don't have siblings alive, then to their children. So it's really important to know who would receive your assets if you do not have a will, because that helps you make a decision as to whether you would need a last will and testament or not. I think everyone should have a last will and testament. It's even more important for people that do not have a nuclear family or do not want the money to be distributed the way that the New York law provides for, in order to make sure that money is going to where the person wants it to go. Not having a will essentially forfeits your rights to decide who is going to control your estate and who receives your money. And instead, the intestate laws decide for you. So,
hello, I just wanted to pop in and give the course code. The course code is WILLS. The course code is WILLS. And I wanted to apologize that you did not get a proper introduction. We had internet issues. We have had a really good run with no internet issues, but thank you for so seamlessly starting the presentation while we were having some trouble. So the course code is WILLS, and I will give it back to Lauren. Thank you so much.
Thank you, and no problem. These things happen. Okay, so now we're going to touch on some probate avoidance. So I told you what happens when someone passes away with and without a last will and testament, and that it requires something called a probate proceeding or an administration proceeding. There is nothing wrong with probate, but you might hear that people want to avoid it. And the reason why some people like to avoid probate is because, first and foremost, it's a public proceeding. So information about someone's net worth, who their relatives are, information surrounding their death may become public knowledge if people search for it correctly. It also includes filing fees. So for example, if your estate is over $500,000, the filing fee to file that in New York is $1,250. So right off the bat, there's fees that have to be paid just to get the petition in front of the court. Probate can be time consuming depending on the assets that need to be distributed, marshaled, sold, etc. It can take years to go through a probate proceeding. When you have a probate proceeding, the estate cannot close any sooner than 7 months because there's a 7-month creditor period where creditors can place claims against the estate. So the court's not going to let you close a probate proceeding any sooner than the creditor period. Usually it takes anywhere from 9 months to a year to close an estate after letters testamentary have been received. The other issue is that any assets that are in the decedent's name alone when they pass away are frozen. No one can access those funds. So for families who have ongoing expenses, such as taking care of a home, paying funeral bills, if there's a surviving spouse that needs funds to take care of herself or himself, having a probate proceeding when there could be months before any letters testamentary are issued can be a big issue for those families because money cannot be accessed, properties cannot be sold. If things are invested, there could be time before anyone has access to those funds in order to sell them or trade anything. A way to avoid probate is by utilizing a revocable living trust. Another way to avoid probate is by having joint assets and named beneficiaries on accounts, because those are considered non-probate assets. But if someone wants full control over their assets and wants to make sure there's money available to pay expenses after they pass away, a revocable living trust is a nice option for doing that type of planning. And a revocable living trust is kind of like this cup. It's an entity that can be created by your client, and your client can be the sole trustee of that trust. It's like an extension of them. It's even associated with their social security number, and for tax purposes, nothing really changes. The benefit of it is it avoids probate, and it allows for seamless transition of assets during after someone's passing, so that those successor trustees can access the funds, pay funeral expenses, medical bills, continue upkeep of property, sell property quickly after someone passes away, and then allow for the assets to transfer more quickly to the beneficiaries. It's revocable. So once you create it, you can revoke it. Once someone funds it, they can get those assets back. They still have full control over their property. So it's a really nice option to beneficiary designations for non-retirement assets because it allows you to sort of have your cake and eat it too. You're able to avoid probate, get money to beneficiaries, have full access to the money during your lifetime, but you can have additional contingencies. So for example, with beneficiary designation forms, you might only name 1 or 2 beneficiaries. Your trusts can have contingent beneficiaries, trusts for minor children built into them, ultimate beneficiaries. If, God forbid, meteor hits family picnic, who would receive those assets? During your life, if someone were to become the creator of the trust and trustee were to become incapacitated, then a successor trustee can step into their shoes and continue acting on behalf of the trust. For those of you that deal with banks and powers of attorney, oftentimes powers of attorney create a lot of issue when need to be presented to financial institutions. Banks look at them and immediately see red flags pop up. They don't like that a power of attorney says that the agents have to act together. They only allow for them to act separately. They want the power of attorney to be reviewed by their legal team. They tell the individual presenting the power of attorney that they're not approving it for that reason. A lot of the times they're wrong and they're acting not as to what the law allows for. And it can create much delay, legal fees, headache when trying to utilize a power of attorney. Power of attorneys are still really, really important to have, but a revocable trust is another way to avoid the need to utilize the power of attorney with financial institutions. So for example, if I have a bank account at Chase that's in my revocable living trust and I become incapacitated, I might no longer be able to act as the trustee of the trust. But my successor trustee, for example, my husband, would be able to demonstrate to the bank that I no longer have capacity, usually by a doctor's letter stating so, and that he's the successor trustee of the trust and he needs to gain access to this account. And typically, I don't see any issues in that situation. While with the power of attorney, because it's an asset that's in my name alone that I have not given any direction to in a document like a trust, they have more issue with it. It's semantics, but for some reason, it seems to be a little bit easier when it comes to the revocable living trust. With a revocable living trust, the benefits of ownership that the individual has personally continue onto the trust depending on the way it's executed. Revocable trusts are typically considered grantor trusts. So for tax purposes, any income earned by a revocable trust is taxed to the creator of the trust, the grantor, at his or her personal tax rate. If they were to transfer real property into the trust and then sell that real property that they reside in, they'd still be entitled to their personal residency exclusion of $250,000 per person or $500,000 for a couple. And when they pass away, their beneficiaries will still receive a step up in basis to date of death value on the value of any assets that they held in the trust. So in a lot of situations, it's a no-brainer. It's also an excellent vehicle to utilize when we're doing tax planning. So for New York, the New York estate tax exemption amount for 2024 is 6.9 million, meaning that if you were to pass away with assets over 6.9, it's actually 6.94 million. If you were able to pass away, if you were to pass away with assets above the exemption amount, you would have a taxable estate. For married individuals, revocable trusts and wills can be utilized in order to do some New York estate tax planning, utilizing disclaimer trusts, credit shelter trusts, other trusts in order to ensure that the full New York estate tax exemption is utilized upon the first spouse to pass away. The federal estate tax exemption is currently much higher. It's over $13 million. That can change. It's under the Trump tax cuts, and it sunsets on December 31st, 2025, and on January 1st, 2026, essentially reverts back to around 6.94 million. So for clients that you have that have potential taxable estates, revocable trusts and trusts that are created under those documents can help in avoiding New York estate taxes, or at least minimizing tax burden by ensuring that all estate tax exemptions available to them are utilized upon the first spouse to pass. The next trust we're going to talk about is an irrevocable Medicaid trust. And for the next 5-6 minutes of my presentation, I'm going to predominantly talk to you about Medicaid planning and what that means. So Medicaid is a needs-based program. Like I said earlier, the types of Medicaid programs that I'm talking about are home care Medicaid, community Medicaid, and nursing home Medicaid. For when your clients need assistance at home or in a nursing home and cannot pay for the cost of their care. One way that people protect assets for Medicaid purposes is by purposefully disqualifying themselves for Medicaid benefits. Medicaid is a needs-based program. So right now, in order to be eligible for Medicaid, your assets have to be below $31,175 for a single individual, or if there's two individuals married on Medicaid, their total resources cannot be above $42,312. So for individuals who are looking to become eligible for Medicaid, they might be interested in limiting their exposure to the cost of care, meaning they want to limit what assets they would have to utilize to pay for the cost of their care if they ever needed help at home or in a nursing home. The only way to protect assets for Medicaid purposes is to give away control over those assets. And for nursing home Medicaid purposes, you have to give away control over those assets more than 5 years or 5 years before you need nursing home Medicaid for them to be protected. The reason for that is there's something called a 5-year look-back period. When someone applies for Medicaid, Medicaid wants to see what you've done with your money over the past 5 years. And if you gave it away, they're going to say, you had money. Go back and use the money that you gave away to pay for your care. Don't come looking at us. But after 5 years, they don't look at what the person did. So, for example, a client of yours can create an irrevocable Medicaid trust, a trust that your client creates, that they're the creator of. They name someone else as the trustee or co-trustees, and they can transfer assets that they want to protect for Medicaid purposes to that trust. They can transfer their home, their investment account, a portion of their non-retirement savings into the trust. And after 5 years, the money that's in that trust would be protected for Medicaid purposes. Right now, there's no look back period for home care Medicaid. In the future, it's possible that there will be a 2.5 year look back period for home care Medicaid. We do not know yet. The transfer of assets into a Medicaid trust give the individuals creating the trust comfort that the assets are not gifted outright to, for example, children and subject to their children's creditors, that they're protected from creditors in this trust. It also allows the trustees to have certain benefits and abilities, such as being able to take money out of the trust. So one thing clients tell me all the time is, okay, I've funded this trust. I don't have any access to the money in this trust. What if I need it? What if I run out of money? Well, the trust can be drafted so that the trustees of the trust have authority to give income or principal from the trust to each other. So let's say you have 2 kids, they're the co-trustees. Daughter can give money to son, son can give money to daughter. Once it's in their personal names, they can do whatever they want with it, including giving it back to their parents. That's another way to undo the 5-year clock if someone needs to go on Medicaid earlier than that 5-year period. Before the 5-year look back period has passed and we have to do something called a crisis plan potentially, or use spousal refusal forms in order to get someone eligible for Medicaid. So some things to consider with a Medicaid asset protection trust is it's not a completed gift typically. So for tax purposes, when a trust such as a Medicaid trust is created, it's considered a grantor trust, and the value of the assets in the trust are still taxable to the grantor at their personal tax rate. For individuals who are doing Medicaid planning, that's typically beneficial because then any income earned by the trust is taxed at the grantor's tax rate. Any assets that are held by the trust would get a step up in basis to date of death value when the grantor passed away. It's still considered their asset for estate tax purposes. Now, if someone has a larger estate and has potential estate tax issues, the Medicaid trust might not be beneficial to them from a tax planning perspective. So a lot of that needs to be weighed as to whether or not they need Medicaid planning, whether they have more tax planning considerations, or if they're sort of in that in between where they have enough money to have a potential have a potential tax issue, but not enough money or type of assets or liquidity to privately pay for the cost of their care long term if they needed to go into a nursing home or needed care at home. So to give you an idea of what the cost of care is in New York, the cost of a nursing home in New York currently is anywhere from around $500 to $600 a day. So it's a very expensive thing to pay for, especially long term. So usually in Westchester, individuals are looking at around $200,000 a year if they're looking to privately pay for the cost of their care in a nursing home. If someone needs care at home, usually anywhere from $25 to probably now around $35 an hour for care at home. So it's not cheap. It can become very expensive. There's a number of ways to limit the cost of your care. Medicaid eligibility is one of them. Doing that asset protection planning in advance is a great way to protect and shield assets for Medicaid purposes. Some individuals have long-term care insurance. I still have clients that purchase long-term care insurance. It can be expensive, but there are a number of policies out there. There's also hybrid policies. The PowerPoint is going to be provided to you, so I'm not going to go through all of the federal eligibility requirements. I believe I already indicated what the resource limits are for Medicaid purposes. So oftentimes, to touch on that, clients will call and they'll say, well, I'm not eligible for Medicaid. I have too much money. But there are ways that you can still become eligible for Medicaid by transferring assets out of your name or to a spouse, even though you're above the resource limit or income eligibility limits for Medicaid purposes, especially in the community Medicaid sector. If someone needs care at home and they, let's say, have a house in their name alone and $500,000 or let's say $200,000 of non-retirement assets, and their income is $2,500 a month, they could still get Medicaid. They would need to gift assets out of their name in order to do so. And they would need to use something called a pooled income only trust to shelter income they have above the eligibility limit. But there are ways to still get eligible for Medicaid, even if your resources are above the resource limit and without paying down your money in order to reach that resource limit. So it's important to, learn about these topics if you're advising clients on them, or speak with someone that does this regularly in order to ensure that your client really isn't eligible or might be able to be eligible, and what the benefits and ramifications, what situation might arise if they do something like that. So with home care Medicaid, it's a two-part process. So first, there is a financial application that needs to be submitted. Once that's approved, there is a personal physical application that needs to be done, where essentially the state is looking to ensure that the person needs assistance with activities of daily living, walking, dressing, bathing, toileting. If that type of assistance is required, then they're determining how many hours of care Medicaid is going to approve for those activities. So for example, in Westchester, we're usually looking at about 4 to 6 hours a day for someone that needs care. It can go as high as 24 hours a day or 13 live-in full-time care at home. It's much harder to get that many hours, but it is possible. There are also a program called the Consumer Directed Medicaid Program, where a family member, other than a spouse, can be paid to provide care for a family member on Medicaid. So that is an excellent program, especially for individuals in northern Westchester, where aides may not be able to take public transportation to those locations. So we talked about the look back period already. And I know I gave you all a lot of information, so I'm going to go to the key takeaways. So some key takeaways of today's presentation are, when speaking with your clients and looking at your own estate planning, it's really important to make sure that simple standard documents are in place, that you have a healthcare proxy, a living will, a power of attorney, that your clients have a valid, properly executed last will and testament, that if they did these wills a number of years ago, they're pulling them out of the drawer, dusting them off, making sure that it still says what they want it to say, that the people that they've appointed as their executors are still alive and healthy and are individuals they would want to handle things for them. If your clients are interested in doing revocable trusts or irrevocable trusts, you're looking at with them, funding those trusts with their assets to avoid probate. And for Medicaid planning, considering an irrevocable Medicaid asset protection trust in order to start the 5-year look back period and get assets out of their name in order to protect them for Medicaid purposes. One thing I didn't mention, which is important, is that retirement assets are exempt for Medicaid purposes as long as your client is taking their required minimum distribution. So your client could have $1 million IRA, and that money, as long as they're taking their required minimum distribution, is exempt for Medicaid purposes. So I am going to be available to take some questions. I hope you all enjoyed this presentation. I'm going to leave my contact information on this last slide, and then I'm sure Judicial Title will make it available to you as well. But I do want to again thank them for having me.
Thank you so much for a wonderful presentation. I just wanted to remind everyone, after the course, I will resend everyone the material and the affirmation, just in case you by some chance did not get it. And please return the affirmation with the course code to me. If you have 5 minutes, I can go through some of the Q&A that we have.
Sure.
Okay. Does an estate include beneficiaries, for example, IRAs or 401ks?
So for tax purposes, one's estate would include their retirement assets. For probate purposes, your probate estate, as long as those retirement assets are life insurance have named beneficiaries and alternate beneficiaries, they would not be included in the probate estate, meaning they're not assets that pass under someone's will.
Should life insurance and annuities be put in an irrevocable trust?
Good question. So it's not something that we talked about today, but there are a number of reasons to put a life insurance policy in a irrevocable trust, or if you're going to be purchasing a life insurance policy, to purchase it in the name of the trust. Specifically for tax purposes, if you purchase, let's say, a $2 million life insurance policy in the name of an irrevocable life insurance trust, and the owner of the policy is the trust, and the beneficiary of the policy is the trust, and the insured can still be me, when I die and the $2 million death benefit goes into that trust, that $2 million is not includable in my taxable estate, meaning that it can be an excellent vehicle in order to allow for wealth to pass to future generations or be available to a surviving spouse without causing someone's estate to become larger and cause a taxable estate. Oftentimes, life insurance policies are also purchased and put into trusts when there is a potential taxable estate in order to have funds available to pay the tax without those funds also being taxed themselves in the estate.
What's the maximum time frame for simultaneous death?
That I don't know off the top of my head. I'd have to research that. I know that you can make it differently. I believe under law, there is a statutory time frame, but in a will, I believe that can be modified in any amount as long as the will is valid.
Okay. Have you ever dealt with an estate where the decedent has federal tax liens? And if so, what are the initial steps to unfreeze their assets?
Have I dealt with an estate where the estate has tax liens?
Yes.
I mean, I've certainly had estates where there have been taxes due and owing. Usually they need to get paid if there needs to be an audit or if there's some sort of concern that the taxes are not valid, then that might need to be a decision from the IRS, might need to be appealed. There is also a hierarchy of expenses that need to be paid when someone passes away. So there's certain expenses that are paid before taxes. There's also taxes can be a preferred creditor in the sense that there's, for example, credit card claims do not get paid before taxes and tax liens.
Can you advise if these forms can be used in other states or if clients move or they reside in other states?
So New York has reciprocity. So for example, if you have a power of attorney that you sign in New York and then you move to Florida, your power of attorney is still a valid document. I do recommend if individuals are moving to another state permanently that they have an estate planning attorney in that state review their out-of-state documents and potentially update documents if it needs to be updated.
Okay, we'll just get to, and then we'll end on time, so I'll just get to one or two quick more questions, and then we will call it. So we end on time. I heard there may be a new rule that disallows the stepped up basis on a house in an irrevocable trust. Have you heard this?
So there was a recent conversations about whether or not certain completed gift trusts where the grantor still has certain rights would get a step up in basis to date of death value. Those do not. The trusts that I'm talking about do get a step up in basis to date of death value because they're includable in the taxable estate of the grantor for tax purposes. I'm happy if that person wants to talk to me offline. I can give them the exact codes and the information that recently came down from the IRS.
Thank you. I have a client who has a power of attorney for her cousin, and a bank won't recognize it because it's the name that she goes by, not her legal name. Do you have any suggestions or thoughts on that?
So any information or paperwork that might show both of her names or an AKA, or that the paperwork that she has going by that name is associated with it would be helpful. Sometimes a strongly worded letter from an attorney does the trick for a bank also. The current law post 2021 of June of 2021 is a little bit more flexible than the prior general obligations law when it comes to the power of attorney being strictly following the statutory short form. So usually it's important to have AKAs for names. So if your client goes by one name, but their legal name is something else, I'd always include an AKA.
Thank you so much. If you have any questions that weren't answered, just shoot me an email. I'll see if I can get them answered for you.
Be happy
Thank you,
to.
Lauren, so much for a wonderful CLE. It was
Welcome.
very, very good. And I apologize again for our little technical glitch in the beginning. And thank you for handling it so well.
Oh, my
Thanks,
pleasure.
everyone. Have a great
Bye.
day.